respondent.
Sir, I am on the behalf of.
One at a time.
I am on the behalf of respondents, sir.
Okay. Okay, Anmol, you're the petitioner.
And
So
how
may I
many
start?
people? Just 2 persons, right?
Yes.
Yes, sir.
All right.
So
Yeah.
2 persons, 15 minutes each, we will be keeping time.
All right. Okay. And who goes
You may
first?
proceed. Anmol goes first.
Okay. All right.
So I'm the petitioner, so I'll be going first.
Okay.
I will defer to Mr. Justice Gupta as he now is. He will lead for us.
Yes, you can
Sure,
start.
A very warm greetings to the bench. The council seeks permission to address the bench as your lordship.
Yes.
Much obliged. This is the councillor from the petitioner's side in the case of 370 Suraksha Sangathan versus the Republic of Avocado. The petitioner has approached the Honourable Court under the writ jurisdiction of Article 32. If your lordships are well versed with the facts of the case, the council seeks permission to proceed with arguments advanced.
Please proceed.
Thank you, lordship. Your lordship, in the present matter, there are 4 major legal contentions. Firstly, whether free speech and expression and freedom over the internet is part of fundamental right. Secondly, whether law and order situation justifies communication blackout. Thirdly, whether mere suspicion is enough to impose restrictions under Section 144. And lastly, whether restrictions imposed in Beverly Hills is reasonable under the Constitution of Avocado. The council now proceeds with issue 1. Your lordship, it is humbly contended that free speech and expression and freedom over the internet are very well within the fundamental rights. And this shall be furnished in a threefold argument. Firstly, fundamental rights are under Part 3 are inalienable rights. Secondly, freedom of press and right to know are intrinsic to freedom of speech and expression under Article 19, subclause 1, subclause A, and Article 21. And lastly, freedom of the internet is instrumental for the exercise of freedom of speech and expression. Your lordship, if you refer to para 2 to 5 of the submission, it is humbly submitted that the threshold understanding of fundamental rights has been settled by the Apex Court from Golaknath versus State of Punjab to Keshav Nanda Bharti to mean the basic mere expression of basic freedoms reserved for the people. Again, in American jurisprudence, the very genesis of where fundamental rights first from Justice Jackson has held that the purpose of Bill of Rights or fundamental rights is to withdraw certain subjects like free speech, right to personal liberty, right to life from the vicissitudes of political controversy. Along with that, B.R. Ambedkar himself has said that the principles of equality, liberty, fraternity enshrined through these fundamental rights are to be held in a trinity and not as separate institutions. And further, they've served the dual purpose of providing justiciable rights to citizens and secondly, drawing limits on the government decision. Now, it is to be understood that those
just
rights...
hold on for a minute. Hold on for a minute. Council, hold on for a minute. What exactly do you mean that freedom of speech over the internet is a fundamental right? You know, when we wrote the Constitution, there was no internet.
Yes, Your Lordship. Your Lordship, the council shall be satisfying this question in the coming threefold argument, as I've said. Now, when I come to Article 19 and Article 21, there's an expanded interpretation that the courts have time and again, be it Navtej Singh Johar versus Union of India or a K.S. Puttaswamy versus Union of India, have expanded the constitutional, the organicness of the constitution has been expanded, and rights within these fundamental rights have also been given a liberal interpretation. Like in the case of Navtej Singh Johar, where physical privacy was considered a personal liberty under Article 21. Similarly, when I'm talking about the doctrine of the doctrine of progressive realization of rights and doctrine of non-retrogression, which has been not only applied domestically but also internationally with the recent most addition to Article 19 of Universal Declaration of Human Rights, which India has ratified, it has said that the recent amendment through Section 32 to Article 19 of UEDHR talks about promotion, protection, and enjoyment of human rights over internet, especially those who work on and rely through internet access. Your Lordship, when I understand, again in Anuradha Basin versus Union of India, the Apex Court has held that technology is an enabler of these rights, is not a right in itself. thus the law should imbibe technological development and also mold its rules so as to cater to the needs of society. It is humbly submitted that the doctrine of progressive realization, non-retrogression, requires that with an evolving society, with a technologically developed society, the state cannot take certain steps which intentionally lead to retrogression of certain constitutional rights and legal rights given by our constitution. In this present scenario, there's a symbiotic relationship between freedom of press, which has already been established as an important fundamental right under freedom of speech and expression through Suckle Papers versus Union of India, Bennett Coleman versus Union of India, through Romesh Thapar versus State of Madras, to be the fourth pillar of democracy. Freedom of press is the fourth pillar of democracy, and it is also a means of discussion of burning contemporary topics and freedom to propagate ideas. And any pre-censorship or newspaper control policy to curtail this would be a curtailment of democratic public participation under Article 19. Furthermore, the right to know, which is a fundamental right under Article 21 and Article 19, as has been held in SP Gupta versus the President of India, it is a characteristic of open government. Now, when I talk about access to internet in today's realm, it is so drastic that the access to internet is instrumental in the exercise of these two very fundamental rights. That is why the doctrine of progressive realization of rights and doctrine of non-retrogression has been applied both internationally and domestically. And because internet has been so profound in the domestic application, there has also been a recent report in 2019 by Internet and Mobile Association of India, which talks about 451 million monthly active internet users by the end of financial year 2019. That makes us second to the senior most or the first biggest internet user, that is China. As we can understand that our lives have been so intrinsically profound on internet access, from our groceries to our transportation to even education tutorials. Internet has actually been a mode of survival for us today. That is why the council contends that the freedom of speech and expression and freedom of the internet do form a fundamental right under the constitution.
See, you have. Can I make myself slightly more clear? You have the right to speak, but do you have the right to necessarily speak on the internet? Does the power of speech also mean the power of reach?
Yes, Lordship. Your Lordship, I very well understood your argument wherein the emphasis is the different modes of communication. Now, the thing is, as I've already cited this report and has been given in the fact sheet, that this particular blackout, this particular communication blackout that has added Section 5 subclause 2 of the Telegraph Act, has also impacted journalists, has also impacted publication, has also impacted circulation. It is to be implied by the fact sheet itself that how heavily dependent Beverly Hills is in today's time for internet to have the access these modes of communication. Along with that, even if we keep aside access of internet, in the current scenario when Section 144 has already been imposed, there have been strict restrictions on the movement of people. Internet is the only way which people sitting at homes be able to understand what the government, what are the steps the government is doing for them, because it is their right to know. It is their right to know under Article 19 and 21. And freedom of press has been interlinked to mean within the ambit, and is crucial for the survival of right to know, as held in Reliance Petrochemicals versus Union of India, wherein it was further concluded that these have been living in a symbiotic nature. And because of the present scenario that has been there, that because of the current COVID outbreak also, that even the most important basic essentials like pleading in front of an honorable court of justice has to be done through internet, it will be very bleak to minimize the utility and the potential of internet in such a circumstance.
Is there any difference between a newspaper and internet?
Your Lordship, may you please repeat?
Yes, did you get the question?
Your Lordship, your voice is coming. If you can please repeat.
All right. Okay. The question is this. Is there a distinction to be made between the newspaper and the internet?
Your Lordship, newspaper in itself was to be taken if we were 2 decades back or 3 decades back in the 80s or in the 70s, where newspaper alone has to be seen in segregation of internet. But today, internet is not used for the circulation of news ahead to the public at large, but also for the generation of the news in itself. News today, if you see online news articles, have the news and media, the news companies today have gone virtual in their extent of dispersing information, and it becomes heavily unfair when you already have 144 imposed, where there's already a curfew, unannounced curfew. On top of that, internet, which is something, if not newspaper, then news through the internet, through the virtual means, has also been blocked. This is where the petitioner contends that while balancing out, the state has made a very disproportionate balancing act, wherein not only the unnecessary or the apprehensive things have been abstracted from minimal access, but also the necessary basic facilities have been abstracted.
Yeah, please proceed.
Your Lordship, if Your Lordship is pleased, may I proceed with issue 2 of the argument?
Please.
Yes, please.
Your Lordship, Your Lordship, it is humbly contended that the law and order situation presently in Beverly Hills does not justify a complete communication blackout, as the measures taken under Section 5, Subclause 2 of the Telegraph Act does not, and the suspension rules of 2017 are not proportional to the situational reality in Beverly Hills. Now, Justice Chandrachud in case Puttaswamy versus Union of India defined the test of proportionality as proportionality which ensures a rational nexus between the objects and the means adapted to achieve them. There's a 4-pronged test to this. Firstly, the action must be sanctioned by law. Secondly, necessary for a legitimate aim. A legitimate aim has to be established. And third, most importantly, extent of such interference has to be in need of such an interference. Now, let us understand the scenario at hand. The Home Department of Beverly Hills has sanctioned this particular blackout under concerned laws. And the legitimate aim here that they have announced is the maintenance of peace and tranquility. Now, this does suffice the first 2 factors, but the extent of interference by way of complete suspension of mobile phones, landline connectivity, and internet services, along with hampering the publication, circulation of press, and the movement of journals, as in the case of Beverly Hills Times, does not seem to suffice the purpose of public safety or peace and tranquility. It does more harm than any good if you understand it this way. There have already been cross-border violations since the inception of the country. Human rights violations by the Central Armed Forces have already been there. In such a scenario where there's such a political and constitutional scenario, when military has been increased, there's an increased alertness within the state. There would be apprehensions of an increased militant reaction also from the state. Taking away basic internet facilities, taking away basic means of information, deploys them and puts them in a further state of distress. Already 55.72% of the population of Beverly Hills suffers from depression, Your Lordship. Depression being in itself a whole other paradigm of struggle, of human efforts to do something fruitful in life, having existential crisis. When internet has been deployed of it, you live in a persistent state of existential crisis thereon. Furthermore, the transfer of information, any kind of violations that are being done on both the parts, either by the militants or the military, how are the journalists supposed to report them? How are they even supposed to report them? Your Lordship, if I may plead for an extension for 5 minutes.
We'd have to proceed quickly to points 3 and 4. Wait, what is your argument on suspicion?
Your Lordship, Lordship, firstly, the state has not given a proper reasoned order, an order in writing, even if it be ex parte, no reasoning order has been done. The test of imminent danger, the state does not seem to have sufficed it. There is, there has to be the evidence of imminent danger has to be as less remote as possible, as in the case of Ramlila incident. Herein, restricting journalists from reporting or having transportation vehicles suspended for even essential commodities is a matter of concern, because the state fails to draw a very direct relation between imminent danger and such activities. When I come to the last contention, the qualification of test of reasonableness as have been established in the under part 2 and part 3 of this of the memorial submission, because the state has failed on grounds of proportionality of action, and secondly on administrative principles of the order deliverance, and failure of citing any evident and imminent threat, because the blackout, the internet blackout happened on 12th of April and the abrogation happened on 13th of April. They had well in advance prepared that any amount of political discussion or deliberation is to be suspended even before the abrogation, thereby leaving no stone unturned that any kind of public nuisance will be created, because blackout has already been created, no amount of communication is there, and curfew has already been imposed. In such light, there is no reasonability to understand why excessive restrictions are there. Your Lordship, if you are pleased with my contentions, may I move forward to the prayer?
Yes, please do.
Yes, Lordship, just a second.
The fourth issue has not been addressed. You want to tell us anything?
Your Lordship, the test of reasonability demands an intelligible differentia, and that this intelligible differentia should have a rational nexus to the objective of the state. Now, the objective of the state is, of course, for public safety and tranquility, as has been told to us, but the amount of interference by even suspending basic essentials. The petition demands the restoration of basic essentials via the internet. The basic essentials have not been provided to the citizens. While the state talks about being parents' party, that is the guardian of the public, but it does not mean that under the state action of whatever deems fit for the state, it takes away even the basic mere liberties of the civilians, which are considered to be inalienable under the fundamental rights. Your Lordship, whereof it is prayed in light of issues raised, arguments advanced, and authorities cited, that the Honorable Court may be pleased to first declare the freedom of speech and expression and freedom of internet as a fundamental right under the Constitution of Republic of Avocado, declare the communication blackout via order dated 12th April as unconstitutional and violative of the Article 19 and 21, issue suitable directions to the concerned authorities for equitable measures to monitor communication and internet services. Lastly, hold the imposition of curfew under Section 144 as invalid and order a balanced withdrawal of restrictions wherever necessary, and pass any order that the Honorable Court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the counsel for the petitioner shall duty-bound forever pay. It was a delight pleading in front of an esteemed bench. Thank you, Lordships.
Thank you very much. Mr.
Yes,
Tiwari?
Mr. Tiwari, what do you have to say in response?
Shall I start, sir?
Yes, tell us. Is freedom of speech and expression over the internet a part of, is it a fundamental right?
Good afternoon, all. If it pleases the court, my name is Yash Tiwari and I appear for the respondent, Republic of Avocado. Your Honor, if it pleases the court, counsel would like to submit that it would address the bench as your lordships. Your Honor, the case before you today deals with the right of freedom of speech and expression in the Article 19, juxtaposed placed with the Article 19 Clause 2 to 19 Clause 6, which is called as reasonable restrictions. In the following cases, I will show that it's correct in its authority pertaining to the national security, interest of the public order, living in the state of civilians. So, on the behalf of the respondent, would firstly suggest on the first issue that freedom of speech and expression and right to access internet. First, we have to look at is not an absolute right, but is subjected to reasonable restrictions. First, for this, we have to look upon the legislative intent of drafters of our constitution. As my opposite learned counsel stated,
Mr. Tiwari, before we come to that, before we come to the reasonableness of the restriction, are you acknowledging that the
no, sir.
freedom of speech includes the freedom over the internet?
Council submits that. I am looking forward to that only. So the first issue is freedom of speech expression is not an absolute right and it's subjected to reasonable restrictions.
Yes. Is freedom
First
of
of all,
a fundamental right?
yes, sir. First of all, for learning the absoluteness, we should see that what was the legislative intent behind this, of the drafters of the Constitution. As my opposite learned counsel states that Dr. Ambedkar in his speech said that Gitlow versus New York, he cited the case Gitlow versus New York, in which it was stated that freedom of speech and information is not absolute and without the responsibility on the shoulders of the state government. The video, three topics were given to see whether what is the nature of the right. Here, the nature of right is sanctioned by law, thus it is permissible. Second, what is the urgency of evil sought to be remedied? The evil sought to be remedied here is basically terrorism, Your Honor, Your Lordship. The basic thing is here is to interest of the public order, interest of the public safety. This rule has been imposed. Third, what was the prevailing conditions at that time? So the prevailing, Your Lordship, the prevailing conditions were utter bad because of abrogation of Article 370 and by modifying the Article 367, which was very, very debatable, and the conditions of the state have already been derogated by the cross-border terrorism, the influx of terrorism, and in many cases, propagation of vile ideas. Council would like to further submit that in the case of N.B. Khare versus State of Punjab, 1960, it was stated that duration and extent is not material, but the circumstances in which the imposition has been authorized and the manner in which it has been authorized, it should be looked upon by the objective standard and not the subjective standard.
So let me just pause there. Just pause there. What is the objective standard that you are advocating in the present case, which justifies a total ban on the internet? So, mind you, see, you said terrorism. Now, terrorism exists with or without the internet. It may be a legitimate state aim that you deny terrorists access to the internet or terrorist sites access to the local population. But there's a vast bit of the internet which is entirely friendly and entirely useful to the people at large who are not terrorists. How do you stop that?
So, Your Lordship, Council humbly suggests that the technology is never static. It is ever changing and it is ever evolving. So the restriction approach should not be narrow, pedantic, and should not be curtailed at all. In the case of Shreya Singhal versus Union of India, paragraph number 36, the immediacy relation, there should be a immediate relationship between the speech and action. And there is only requirement of incitement that there is only requirement of incitement, which should be a tendency. It should not be an intention completely. There should be only tendency. Thus, the clear and present danger test is buttressed by the Justice Rohinton Nariman in this case. It is further stated that in K. Abbas versus Union of India, social interest overrides individual freedom. And
to what extent? To what extent?
And Your Lordship, as you asked, as your query was about the what internet width. So that width only is like a matchstick, to the prevailing conditions of the state, which serves as a gunpowder. So if and the users serve as it is ever evolving, and there can be no restriction because most of the internet is anonymous, and it has been stated in the reports that 90% of internet exist in the dark web. So the dark web has no face, dark web has no name, and we cannot curtail it upon. So just to curb that and nip it, nip the evil in the bud, we have employed this provision that so that if there will be no internet, there will be no incitement to an offense, there will be no false propaganda, there will be no instigation of incendiary speeches that will pertain the conditions of this valley to be bloodless, bloodbath, merciless killings, and whatnot. So the foremost duty of the state was to save the limb, lives, and property of the people.
Proceed.
Yes.
If it,
Do you want to go on to the other parts?
yes, sir. I would like to, Your Lordship, I would like to further move on the second issue.
Please proceed.
Yes, tell us.
Second issue says that Section 5(2) of Telegraph Act is valid or not. And I can pertinently say that Section 5(2) is very much valid because, first of all, this issue has to be started with the notification under Section 7 of Telegraph Act. Section 7 of the Telegraph Act states that any central government can impose any rule and impose any order for the temporary possession of the telegraph or any instrument under it. Under Section 5(2), Council would like to refer to the Section 5. Under Section 5, it is stated that on the occurrence of any public emergency or in the interest of the public safety, the central government or a state government or any officer specially will be authorized in behalf by the central government, and if satisfied, it is necessary or expedient so to do in interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign state or public order, or for preventing incitement to an offense. So under this case, we shall look upon to the rules which were made under temporal suspension rules of public emergency and public safety 2017. First of all, Section 5 Clause 2 should be read with the Rule 2 of the aforementioned rules, and it said the provision of curtailment should contain reasons, and it should contain the reasons which were unavoidable, which were necessary. And to say that it was completely curtailed is a false, because nodal officers under Rule 4 were employed to see if there is a need of communication. So under Section 4, if there is a need of communication, nodal officers were employed for the requisitioning of the public justice and for the social order. Further, sir, I want to cite the case of Hukum Chand Sham versus Union of India and People Union Civil Liberties versus Union of India.
Proceed.
In this case, court held that occurrence of any public emergency or the interest of public safety. So it should be Your Lordship will further stated that in interest of the public safety should be read with in a cognate sense of occurrence of any public emergency as interpreted by the Nocitor Associates Interpretation Clause. And it should be read in a cognate sense as it derives color from each other. So I state that occurrence of any public emergency or in the interest of public safety are the sine qua non for the application of provisions of Section 5 Clause 2. Unless these two conditions are satisfied, the government cannot exercise its power under the said section of Telegraph Act, and even though there is a satisfaction that it is necessary or expedient to do so in interest of sovereignty of India.
You can just give us your response to third and fourth issue.
So, Your Lordship, on the third issue,
I'd like you not to get into any details. Just give us your response to 3 and 4.
Council would like to suggest that there should not be a clear and imminent danger present in the case. an apprehension, as stated in the Babula Prate case, an apprehension of danger is enough for imposition of section 144, just as the apprehension should not be remote, conjectural, and far-fetched. Second issue is stated in the Karnataka versus Praveen by Togadia 2004. Court should not interfere in the administration powers because imposition of section 144 is clearly an administration provision and large and best to assess it to handle it for the people in the ground and the discretion of the magistrate who are affirming the case from the ground, who know the root cause of it. So thus the court cannot interfere in this matter unless it is ultra-virus, unless it is exceeding the duration, or unless it is arbitrary and excessive. On the point of, on the further case under issue 4, Your Lordship, Council would like to submit that Council would like to submit that this order was perfectly reasonable because a test of reasonable lays down that it should have a direct and proximate link. So the direct and proximate link can be described upon because if it was not imposed, it would have a domino effect and it would have triggered community in danger. The community interest would have been in danger. And it shall be followed by the state of Bihar versus Shalbara Devi, which states that security of the state with interest of the interest of public policy clearly implies that actual result of the act is immaterial. We should only discuss upon what is the effect. What will be the effect? Actual result will be immaterial. It says that.
Okay.
Further, council would like to conclude that this measure is a completely illocutionary measure and no temporal gap between the utterance and effort has been recognized. There is no temporal gap between the utterance and the effort.
Is there any rejoinder proposed?
Yes, sir. Yes, Your Lordship.
No, we do not have time for a rejoinder, I believe.
All right, fine. Then thank you very much, both of you.
Thank you, both of you. You have done well. You have obviously come prepared with a lot of authority. He is on the point. The hard work is showing. Let me just end on a little story. You know, many years ago, as a young man, Chief Justice Thakur, T.S. Thakur, went to buy the library of Mr. C.K. Daftari. And Mr. C.K. Daftari gave him some very valuable advice after the library was bought. He said, speak slowly, speak clearly, and never mind the judge. So therefore,
Yes.
Speak slowly, speak clearly, never mind the judge. You've both done well. Mr. Justice Gupta and I will confer, and we will obviously convey our marks to the organizers. Thank you very much.
Thank you so much.
Thank you very
much, Lordship. Thank you very much.
Thank you, sir. On behalf of ICLU, and I know your time is very precious. We can only express our gratitude to you, and thank you very much, sir.
No, so what is the procedure now?
No, we will send our mark sheets to them, and they will add it up and inform and add it to this meeting.
Okay, fine.
Yes, sir. Yes,
Okay.
I will do that. Okay.
Thank you.
Right. Thank you, sir. Thanks.
Bye.
Sir. Thanks.
Hi, thanks a lot.